Ah, there we go. Peter's joining. I'm Maurice Crispy of Schindler's Attorneys. We are joined by Derek of the IQ Business Group, by Dean Wright of Schindler's, by Ian and Peter of Engaged. We've changed the format a bit since last week. What we did for the last 2 weeks when it comes to these webinars is deal with the Act, go through the Act and explain it in detail. What we've done is that particular video of Fridays is now on the Schindler's page. It's going to get posted on the COBRA page, so you can go through that. And that's really taking you section by section through the Act, which is helpful. What we'd like to do today is open up to questions. It's a small group. There was a technical issue with the registration, so apologies for that. But if you can ask questions that are specific possibly to your business, to the circumstances you find yourself in, please do, because that's probably the best way. Well, it is the best way to engage. What I will be doing is I'll be asking the panelists to deal with certain important issues which come up and are essentially the topic of the day in relation to the circumstances that we find ourselves in. So I'm going to kick off just by giving a brief overview of business rescue, and then we'll start dealing with the questions. So business rescue came in approximately 10 years ago, and it's I'd say the most important aspect of business rescue is the temporary relief that it gives to a company or a closed corporation in relation to any claims that may be instituted against the corporation. It's called the moratorium that kicks in, and during the business rescue process, what happens there is claims cannot be made against the state, save in circumstances, and not the state, the company, save in circumstances where the business rescue practitioner has not suspended contract. So there's case law to the effect that if the business rescue practitioner has not suspended the contract by way of a notice in terms of the Act, a cancellation by a landlord is still proper and an eviction would still be appropriate. So it's very important that you select the right business rescue practitioner. Obviously, COBRA has those practitioners that they have the experience, and you have the benefit of the pro bono element. So let's kick off by me asking Peter, Peter, the test for business rescue. When is it appropriate for a company to go into business rescue? But I ask, particularly in this context, in relation to COBRA.
Reese, look, I mean, under normal conditions, the defining factors laid out in the Companies Act, but also in Chapter 6 and Chapter 4. And basically, if a company cannot see its way clear to paying its debts as they fall due over the next 6 months, then it's classed as financially distressed, different from the classic insolvency test of do assets liabilities exceed assets. So if the company meets that test, then it certainly should go into business rescue. However, the board or the owners of the business can take advice on how to survive. And this is classically how companies have continued trading. And when they go into insolvency, everybody claims they were trading recklessly because they were insolvent. But the company can prove either they had bank facilities or the shareholder was putting more money in, et cetera, et cetera. So the same would apply in this situation. With a company that is facing it, certainly a smaller company, then COBRA obviously provides a platform to come in to get that advice and to help the business survive outside of rescue, because at the end of the day, we do try and establish a position where companies can continue trading and not necessarily have to go into rescue. Whilst rescue is a fantastic protection against numerous challenges, as you've rightly said, a complete moratorium, and it is absolute, it's an iron cage. What does happen is there's a negative publicity, possibly, becomes quite difficult to continue getting supplies from your creditors if you haven't paid them, obviously. And it just unsettles people and gives the competition an opportunity to try and attack you or your customers. So When I say attack you, I mean attack your market. So if you can start a rescue, it does make sense to try and do it way clear to paying your liabilities, then you should be going into rescue. And indeed, it is the protective and sensible thing for a board to do.
Yeah, I think it's important to point out that a business or the board is obliged to put business rescue to the vote in circumstances where the company is financially distressed, which is not being able to, it's conceivable that you won't be able to pay your liabilities as and when they fall due. So what has to happen is there's an obligation in terms of the Act to put the company into business rescue, or to put it to a vote. If the vote goes against business rescue, you've got to notify your employees and your creditors that there was a vote, but the company is financially distressed and that the board voted against. But in doing so, the board must give reasons as to why it voted against. A good reason is that you've come into the COBRA ecosystem with professional mediators who are on a pro bono basis going to be trying to mediate those the liabilities, the debtor-credit relationships, with a view to keeping you out of rescue. So it's a good reason to not go into business rescue. And in fact, we've actually got a notice. If you email us, we'll provide you with a notice to your creditors explaining this. Because once they are aware of the COBRA ecosystem, they come in and then we deal with their creditors in turn. But importantly, you have to put it to the vote, and COBRA is a good reason not to.
Maurice, can I say something? Just a quick point. The type of business that you own or the type of business that you operate is also a key determinant in whether you decide to go into business rescue or not. It's something you've got to think about and something you've got to consult about. For example, it's much easier for a retailer to take the business rescue decision than for a construction company to take the business rescue decision. Because a retailer is not going to really affect your customers. Your customers won't even know that you're in business rescue, the people who are buying from you. Yet, if you're a construction company, very few companies are going to give you work. You're going to get very little construction work if you're in business rescue. So those things all need to be thought about. Typically, a construction company, you'd want to get in and out of business rescue as quickly as possible so that you can carry on getting new work. You'd want financial institutions who could provide guarantees to your customers and so on. But there's a lot to think about, and the decision to go the business rescue route varies substantially from business to business, from industry to industry, and you need to consult with us about it so that we can explain to you the nuances of each industry and how it relates to the business rescue decision.
Yeah, certainly. Okay, great. So now there's a resolution. It's been decided to put the company into business rescue, and a business rescue practitioner is appointed. Whilst I've got you here, tell us about, I think, importantly, the relationship that the business rescue practitioner needs to have with both creditors and employees, and also the time frame. So if you just explain to the audience how it works.
Okay, certainly. So the business rescue practitioner gets appointed within 5 days after the company going into business rescue. The business rescue practitioner then has 10 business days in which to hold what we call a Section 147 and a Section 148 meeting. Section 147 meeting is a meeting with the creditors to basically explain to the creditors that he believes there's a reasonable prospect of returning the company to a solvent going concern, or giving creditors a better return than they would get in a liquidation scenario. At that same meeting, the business rescue practitioner will invite creditors to submit claims, and he will invite them to form a creditors committee if they so wish. Typically at the same time or straight after that meeting, we'll hold the Section 148 meeting, which is the meeting with employees or employee representatives, or the trade union, as the case may be, during which we explain the same thing to the employee representative as we explain to the creditors. We explain to them that there's that we believe there's a reasonable prospect of returning the company to a solvent going concern, or a better return than in liquidation. So yes, the relationship with creditors and the relationship with employees specifically has to be dealt with very carefully. You know, often there's retrenchments involved, and you know, it has to be sold to the employees in the way that it really, you know, in the way that it is. You know, the facts have to be sold to them, and that's the fact that the retrenchments are necessary in order to save the company. If we don't effect the retrenchments, then there will be no company in 3 months' time. And should we get the company back on its feet, then there'll obviously be the opportunity to employ those people again who've been retrenched. Okay, let's just go back to the timelines. So 10 days after the appointment of the practitioner, he holds the first meeting with creditors. 25 business days after the appointment of the practitioner, he's then required to publish the business rescue plan. Now, I think in future webinars, maybe next week, we'll deal with the actual business rescue plan on a very detailed basis. We can potentially take people through a sort of case study business rescue plan. But a business rescue plan basically entails the turnaround strategy, exactly what's going to be done to turn the company around. It's got everything that a business plan would typically have in it, as well as breakdowns of creditors classes, breakdowns of which creditors are secured, which are unsecured, and which are independent, which are non-independent. And very importantly, it has a comparison between what the company is expected to get in a business rescue scenario, or what creditors are likely to be repaid in a business rescue scenario according to the business rescue plan, versus a liquidation scenario. So business rescue always has to give creditors a better return than they would get in a liquidation. So we do a liquidation calc, which is typically just a liquidation and distribution account, as if the company was being liquidated, and we compare that to what the business rescue plan foresees creditors getting. And then it has you need to publish 3-year financial projections within the business rescue plan to show how the company will proceed on an income statement, balance sheet, and cash flow basis going forward. 10 days after publication of the plan, then we hold what we call a Section 152 meeting, and that is a meeting for the business rescue plan to be voted on by creditors. Now, the vote of the creditors that is required in order for the business rescue plan to be adopted and approved is 75% of all creditors need to vote in favor of the plan, and that 75% is by value, and it is according to the creditors who vote, be it in person or by proxy. And in addition to the 75% of total creditors who vote, 50% of independent creditors, which excludes directors' loans and shareholders' loans and anyone related to the company, 50% of independent creditors need to vote in favor of the plan in order for it to be approved. Once again, it's by value, 50% by value, and it's the creditors who vote. Once those votes have been passed, then the plan is approved and the business rescue practitioner can implement the plan.
Can you just, through this process, just detail what the role of the business rescue practitioner is, apropos directors? I think the audience would like to know where they fit in as directors.
Absolutely, which is a very important question. The business rescue practitioner has ultimate control of the board of directors. In other words, the business rescue practitioner, the directors have to, in terms of the Companies Act, work with the business rescue practitioner. They have to cooperate with the business rescue practitioner. So this is a very, very important reason why the choice of the business rescue practitioner is so critical, because you're putting a guy in charge of your company who has ultimate control of your board and who makes all the decisions. If you make the choice of the wrong business rescue practitioner, it can obviously end in disaster. The choice of the business rescue practitioner is something that has to be very, very carefully considered. The right business rescue practitioner is not somebody who will come along and kick the CEO out of his seat and just take over and do his own thing. The right business rescue practitioner is somebody who will work with the board in a very, very consultative process and will effectively find the areas where the board might be lacking slightly and be able to plug those holes, but effectively working with the board. We always say that we will never know as much about a company as the board of directors and the CEO, the guy who started the company 20 years ago. We will never be able to replicate the relationships that he has with his customers and with his suppliers and with the public in general. We are not there to take over the role of the CEO or the board. We are there to work with you, although ultimately the board reports into the business rescue practitioner and is accountable to the BRP.
Yeah, I think that's important. I think it's important for the audience to understand that there's good faith when it comes to business rescue practitioners, because the only way that they can get things right is by getting a plan signed off. Whereas liquidators are, they don't have that. There's no, they succeed by virtue of a liquidation, which will always take place. So, and on that score, maybe we should just deal with the fees. A liquidator's fees are set, it's a percentage, 10, 6, and 3%, whereas a BRP, they work on a hourly rate. Now, in the COBRA environment, what we've done is we've providing a pro bono service, because if you guys can't afford a business rescue, obviously you're distressed, we want to get you out of that position. I just want to turn, a lot of questions have arisen in the past, and I think, again, a very important topic is people are putting money in to fund or to pay salaries. And important advice is, if you're going to be putting money in, do so after you've gone into business rescue. And I'd like Peter to pick up on that. Peter, why would you, in your mind, say business rescue is important for the injection of further funds into the business?
Maurice, the provision of what we call post-commencement finance, PCF, is critical. Obviously it is. Everything's frozen. Very often the bank account is frozen, and you've got to continue paying wages and paying for current suppliers, i.e. post-rescue, so you can keep the operations ticking over. Now, anything that comes into the company, in the practice of business rescue, we talk about drawing a line in the sand. So anything pre the line is frozen, so nobody can be paid. Everything post the line is preferred. So anybody putting money in post-rescue is then preferred, and they've got to be settled before anybody else can be settled whilst in rescue. So it's, and it often is the case that shareholders stroke directors will continue feeding money into the business up to the point of business rescue, then go into rescue. And of course, those loans that they put into the company are immediately frozen. So it's infinitely sensible to go into rescue to protect the new funds that you're putting in. Obviously, the banks are aware of this, and the legislation is written that way so as to attract funding into a company in rescue. If it weren't the case, then it would be almost impossible to raise funding. But it does protect you, and as I say, you're preferred over everybody else other than the practitioner's fees. The practitioner stands at the front of the queue, and then anybody providing post-commencement finance second. The other thing to remember is anybody putting money into a company in rescue, the practitioner rather can use the assets of the company that aren't already encumbered to secure further funding into the company. So, you've got a large property and it's only mortgaged, and the mortgage is only 50% of the property. There's nothing to stop the practitioner raising a second mortgage over that property in order to give security to a post-commencement funder. The other thing to watch out, of course, is that it's in the risk area. So the interest rates, if it's in the general market rather than the banking market, can get a little bit heinous. So clearly one's got to negotiate quite hard as a practitioner with anybody providing funding to make sure the business is not killed by the cost of the post-rescue funding.
Absolutely. Peter, just adding to that, if you provide, if a financier provides post-commencement finance, once the company is in business rescue and takes an asset of the company as security, even if the company goes into liquidation, that loan ranks right at the top. In a liquidation scenario, the business rescue practitioner's fees drop right down to being a concurrent creditor, but secured post-commencement finance ranks right at the top in a liquidation, should the company end up going into liquidation.
We've got a great question to the panelists. I'm just going to read it. I'm a permanent resident. My husband is an SA citizen. We are 50-50 in a closed corporation. Do we qualify for business rescue? The answer is absolutely. There's a section 66(1)(a) of the Close Corporations Act that specifically makes provision for business rescue. Whether you're a resident or not is of no consequence. So yes, you do qualify. You are in the same position as a company.
The only thing that needs to happen there is that both parties need to agree on the business rescue decision. Because you're 50-50, and we've often had this, whether it's a company or a CC, one party wants it to go into business rescue, the other doesn't. Both parties need to agree and pass the necessary resolution for it to go into business rescue.
Sure. I'm going to just jump in and deal with the legal aspect, and that is, again, something which comes up quite often, and that is the case of staff and their rights in these circumstances. So when it comes to staff in business rescue or out of business rescue, they need to be treated the same. Their rights are not diminished as a result of the business rescue. But we have these peculiar circumstances, and we've heard about vis major and contracts being suspended, and what is the situation with staff who are not rendering services because they're unable to render services. If retrenchments are contemplated, the law is that you have to consult with your employees, and the consultation has to be meaningful. That's in terms of Section 189 of the Labour Relations Act. Historically, or the precedent is that that consultation should take a relatively lengthy, or it should be a meaningful consultation. There should be sufficient time provided to employees to consult on aspects such as the reasons of dismissal. Views have been formulated that those time periods can be curtailed because of the circumstance. You don't need to consult on the reasons as to whether the reasons are bona fide or not. We all know the reasons. When it comes to employees that you do not have to retrench, there's a principle in our law that if you're not performing services, there doesn't have to be counter performance. And the view has been adopted in legal circles that you do not have to pay in those circumstances. That is a vis major, and there's no obligation to pay. If you're striking a deal with the employees, though, you have to get their agreement in relation to that deal. So if you intend giving them a haircut or proposing a haircut of 75% or 25% or whatever it may be, get consensus with the employees, consult with them on the issue. We've dealt with how a business rescue plan is adopted, but we haven't dealt with what happens if the vote fails.
Let me jump in there, and then Peter can jump in as he wishes. If the vote fails, now let me just point out that the whole business rescue the process of preparing a business rescue plan and presenting it and publishing it and so on is really a big negotiation process with creditors. Normally, by the time we go into the Section 152 meeting to vote on the plan, we already know what the vote is going to be. There's nothing stopping us from negotiating with creditors prior to the publication of the plan to get their feel as to what would be acceptable or not, as long as we're treating all creditors fairly, as long as we're not giving certain concessions to some creditors and not to others, which we'd obviously never do. So we get to the Section 152 meeting. The creditors have already had 10 days to consider the plan. We present the salient features of the plan, and then we put it out to vote. There are instances where a creditor will go into a business rescue process, and sometimes it has been a major creditor, and for whatever reason, they are not interested in business rescue whatsoever. They only want to see the company liquidated. Once they vote against the plan, then it is the duty of the practitioner to say to the creditor, how would you like us to amend the plan in order for you to approve it? If the creditor then wants to, if he's prepared to put forward amendments and for us to amend it and then to vote in favor of it, great. As long as the amendments are reasonable, as long as it makes the plan still implementable, then we'll pass those amendments and the plan can be voted in. If the creditor still refuses to put forward amendments that would make it acceptable to them, still refuses to vote in favor of the plan, the practitioner then still has the option to declare that the plan has not been adopted, but then to go to court and to apply to court to have the vote of the creditors set aside as inappropriate. And there has been case law to this effect, and it's quite interesting because in one case, and I forget the name of the case, but the business rescue practitioner applied to court to have the vote set aside as inappropriate. The court only ruled 2 years later. However, once the practitioner had applied to court to have the vote set aside as inappropriate, he then went about implementing the plan as if the business rescue plan had been adopted. By the time it got to court 2 years later, the business rescue had actually been a success. And the court found, at the same time, as a result of that, the court found that the vote of the creditors was in fact inappropriate, and that the business rescue plan should have been adopted, and effectively allowed the business rescue plan to have been adopted.
The benefit of hindsight.
Yeah, exactly. So that is an option for the business rescue practitioner should the plan be voted against. Peter, I don't know if you want to add anything to that.
Look, I think the important thing in publishing the plan is a lot of behind the scenes negotiations have to take place. If you are suspicious that you might have a acrimonious creditor, it's quite important to try and get those creditors on board. And it does become a bit of a numbers game because you need the 75% vote. It's quite easy to calculate which creditors you need to support the plan. And if you do have one outlier, then if they're not prepared, as Ian said earlier, we would try and cooperate with the creditors. But you do get situations where you have an outlier, and he's going to, excuse me, vote against the plan. And in that case, communication becomes all the more critical. I have had the bizarre situation of two companies that were interconnected via loans. I got permission from the company that was owed the money to take on both rescues. It was a financial services company. And I ended up with a situation where I had what the lawyers friendlily call a Mexican standoff. I couldn't get the plan through because the one that was being pushed by the debtor company wasn't going to be supported by the main creditors of the main company, of the creditor company. So it took it took me 2 years to negotiate with a bunch of 275 investors to get them to agree to a sensible plan that suited everybody. So that was an extreme case, but it was a case where if you just keep at it and you keep presenting viable options to them, and indeed I managed to get 100% of the guys paid in a fairly acrimonious situation. So it is possible, but it calls for elephant thick skin and an ability to communicate with all.
Yeah.
We got some questions. Sorry, carry on. What you done?
Peter talks about behind the scenes negotiation. I just want to point out there's nothing untoward about that. It's not making deals with some creditors that are not available to other creditors. Any negotiations that happen with specific creditors have to be able. We have to. What I'm trying to say is it's a very, very transparent process. Those negotiations have to be able to be disclosed to all the creditors as part of the plan. So,
whilst I got you there, yeah. I've got a question from Carl. If my business goes into business rescue, do I need to inform my customers' debtors? The answer to that is yes, but just be mindful of the fact that the stigma in relation to business rescue is very, very different to where it was a month ago. I don't believe there is a stigma. If anything, it's a responsible thing to do. Putting it to the vote is the lawful thing to do. Not doing so would be you acting contrary to statute.
Can I jump in there? Sorry. And Peter's normally very good at answering this question, but let me give it a go. As far as customers and debtors go, there is no statutory, in the Companies Act, there's no statutory requirement to inform your customers and debtors because they are not recognized as affected persons. Affected persons need to be notified. Affected persons being your creditors, your employees, and your shareholders. Customers and debtors technically do not need to be notified. Obviously, it is a good ethical practice to notify them. However, if you're a retailer, how are you going to notify all your customers and debtors? And why should you notify all your customers and debtors? Because it's not prejudicing them in any way if they're not notified. There is a requirement, though, that in practice, Peter, you can tell us exactly what the requirement is, but on the company's website, it should be advertised that the company is in business rescue, and therefore that would be accessible to all the company's customers and debtors.
Yeah, and the requirement there is the company must put up a notice. Can't remember the exact wording, but must put a notice to the effect that they're in business rescue. So what most companies do is you've got that certificate of incorporation or certificate to commence business or some health and safety certificate in your entrance area, your reception of the offices. You stick a label below that saying that the company's in business rescue, and then it should go on the website. So if that is going to be a huge challenge to business, what I've seen a lot of companies do is they just take the website down and stick it under maintenance. So anybody accessing that isn't aware of the fact that it's in rescue. My view on this is that morally a company should tell their customers, but Ian, as you rightly say, I mean, what was Studdefields going to do the day it went into rescue? As a company, as a customer comes up to the till, advise them they're in rescue. You know, it's impractical. Let me just remind us all, though, is very often your customers become creditors. And that's very common in the travel industry or the hotel industry, the airline industry. Anybody paying a deposit is immediately an affected person because they're a creditor. So don't fall into the trap if you're a travel agency thinking, I don't have to advise my customers, because if you know that a travel agency's in rescue on an airline, think of SAA, who's going to book in advance and pay a deposit? But if you have paid deposits, also the construction industry, customers often clients pay deposits on a construction contract. For that deposit, they are a creditor and therefore have to be advised. So yes, but generally, as Ian rightly says, debtors, customers do not have to be advised during rescue, legally not in the law. Morally, different story.
And then Alexis says, is the practitioner allowed to proceed with the plan pending the court decision? What if the plan was not successful? I haven't studied the case that Ian mentioned. I'm going to, because I need to determine what in fact was the test and why did the court come to that conclusion, because it would be peculiar for the court to have accepted evidence 2 years later. Well, first of all, it sounds like judgment was reserved for 2 years, so then how would the matter have been argued in 2 years' time? How would the judge have had that evidence on record? So let me have a look at that. And if you want to email me directly, please do crespi@schindlers.co.za, and I'll give you an answer to that. Also, bear in mind, to everybody who's on this, we have pro bono consultations with professionals and your team to deal with specific questions relevant to your business. So please set those up. We have plenty of those, and we find them to be really, really fruitful. All you've got to do is either email info@COBRA, or you can email any one of us directly.
Maurice, can I ask you a question on that? Because it's quite an interesting conundrum. If a company has a liquidation application against them, so 345 application for liquidation, and the company settles it in full, including interest and possible legal costs, can the company merely assume that the application won't be pursued? Do they need to get the applicant to agree that it's set aside, or do they have to go to court to do that? I can't imagine the courts being pleased if somebody presents a liquidation application at court when they have actually been paid in full. But as I understand it, is the law clear on that?
Yes, yeah. In fact, I personally dealt with the matter, which involved Four Ways Precinct. We launched an application to liquidate. They wrote out a check in the region of about 2.2 million, which took away, the moment that happens, they paid and they took away our legal standing, because now you need to be a creditor in excess of 100 rands in terms of the Old Companies Act to have legal standing, locus standi. So the moment they took that away, we couldn't proceed with the application. But what they did then is they applied to court saying that They wanted the costs of the application because we never proceeded with it. And we actually had to argue this. And I mean, I was completely taken back by this. And the court was actually very, very, very hard on them for having done that. And he didn't order punitive costs, but was very, very close, the judge. So you simply do not do that. It's actually an abusive process, Peter. Once your legal standing's taken away, they can't do anything, and they'll probably be met with a punitive costs order.
Well, Maurice, that's good to know, because obviously, I don't think we've covered it yet, but you can't go into rescue if there's a liquidation application outstanding against the company. Now, from experience, what you often find is your biggest customers are not applying because they rely on you and they wanting you to do well because it means they do well. It's normally the printer around the corner, or your auditor, or worse still, your lawyer, who applies for liquidation because they're a small creditor in the company and don't see the company as their main lifeline. So it is important to understand that whilst that's outstanding, that liquidation application, you can't apply for rescue. But if you then paid it in full, including interest, I then assume that you'd be able to file for rescue.
Peter, yeah, no, absolutely. Just on that score, and I think it's an important topic. In liquidations, if the petitioning creditor who takes the matter to court to liquidate you does so on a debt that's disputed, there's in our law what's called the Badenhorst rule, that you cannot proceed with a disputed liquidation, and that's considered an abuse. And in the Badenhorst judgment, they actually said that punitive costs are deserving in those instances. Peter, what happens with a disputed claim in business rescue?
A disputed claim, the practitioners separates all claims between, well, first of all, he's got to accept a claim. So he has the accepted claims, undisputed, and then he will record in his plan those that are disputed. The disputed claims don't have a vote. So Ian talked about the 75% majority vote required. The disputeds are recorded in the plan. And obviously the practitioner's got to try and settle those disputes during the course of pre-plan publishing, pre-plan being voted through, and then post. So once the plan is adopted, and that becomes, if you like, the, in inverted commas, law under which the company is operating, the practitioner continues to try and settle those claims in whichever way. If it cannot be settled, well, then he rejects them. Be warned, though, prescription aside, if a company is then taken out of rescue and there's outstanding unresolved claims, they might rear their head again, and you might find the silly situation that somebody applying for the liquidation of a company that's just been rescued.
Yeah, and I think it's important to also emphasize that liquidation is always an option. The conversion into liquidation is always an option, and if the litigation takes too long and is too costly, it's conceivable that the litigation may lead to the conversion of business rescue into liquidation.
Marisa, I mean, the other side of that, of course, is I've had a case, I was on the other side, where a plan was adopted. There was a disputing creditor. The practitioner plowed through. He did an organized wind down, which you're allowed to do in rescue. So he paid out all the creditors better than they would have got in liquidation. And he was left with 2 disputed creditors. He then liquidated the company.
Yeah, and that's the difficulty with the Oakdean judgment. The Oakdean judgment basically put a span in the works in relation to better return to creditors for creditors. The judgment basically said that it shouldn't be handled as a liquidation, but in practice, post that judgment, it is, because the act is pretty clear. It says as much. How do you guys accept proof of claims?
There's no formal. Sorry, and I'll blow in you.
No, go.
There's no formal process. It's good practice, good corporate governance practice to have a claim form that you send to creditors, so which they then present to the company either at the first meeting of creditors or during the entire process. Some practitioners will only take claims up to the date of the vote on the vote of the plan. Others will state in the plan that they're keeping the plan open for claims, which I think is the fair thing to do, especially if you've managed to get a plan out within 25 days in terms of the Act. You can obviously extend that date, which is the norm, because it's quite difficult in 5 weeks to get a plan out. But once you start extending, it's less critical. But if you're a creditor caught off guard and you didn't realize the company was in rescue and you weren't advised of it, then I think it's only fair to allow a late claim. That would be the case with, you know, large financial funds where you've got multiple, you know, thousands of investors where they're all trying to claim their money back. Very often people don't keep track of where their investments are. And then I think it is only fair to allow people to claim up until the point of the finalization of the rescue. But any claim coming in a formal way that we do it is not necessary. You can take the books and records of the company and say those are the claims. You then ask for proof of those claims, and people have to, especially if the company's disputed them already. If you, in your work, have decided, which often is the case, that this company's books of account are well maintained and that the creditors' ledgers are well maintained, then it's not necessary to have formal claims. But it is a good practice just to have a file where people put in their claims, state exactly how much is there, and some odd things happen out there. Very often you get a claimant claiming less than's on the books of the company. So it doesn't always go the negative way. It sometimes goes the positive way for the company.
Great. Thanks, Peter. Before we conclude, I just want to call for more questions if there are any, and also mention that if you want, I can call you up to talk. If you want to ask a question, just raise your hand and I'll call you up. I think an important aspect that I want to deal with is the question of suretyships. Now, you have a situation where the company, there's a moratorium against the company in relation to, let's say, a bank overdraft. The bank cannot sue, but now you've stood surety for that. What's the position there? Well, the law settled on that. You still remain liable as a surety. What's important is that one have regard to the wording of the suretyship to determine whether you are liable. The majority of suretyships cater for a situation where they can proceed against the surety despite a moratorium against the principal debtor. I don't have any hands going up. So unless there's anything...
Maybe if I could just pose a question, because one of the things that the practitioner is allowed to do is he can call in consultants to assist in the rescue. You know, very often, if unfortunately you do come across them where there's been fraud, the practitioner is required to investigate any wrongdoing in the company. If the company is continuing to do it, he needs to make sure that management ceases whatever they're doing. He then is required to report it to the authorities. It's not clear which authorities, but very often it's obvious. For example, a company that's on the stock exchange, you would report it to the exchange, etc. But the practitioner is allowed to seek professional assistance. And from that point of view, I mean, as practitioners, we don't have a vast network or vast employment of people who are just waiting for rescues to provide either legal or financial or tax input. And I think it's just important to note that, you know, COBRA, we have tied up with IQ. And the point of that is that's the services IQ supplies. And I don't know, Derek, if you just want to comment briefly on, you know, what the service provision would be from IQ into the COBRA network.
Yes, certainly. Thank you. So from our perspective, basically what we will come in, we've got a whole force of about 700 staff members that we can throw at this, as Adam, our CEO, has indicated. So what we do is we've got a vast consultancy form of business improvement as well as process efficiency to help out around that. We've also got change management in control to help with the changes within staff, and I think that is very, very important as well. Because of this turmoil that the company is going through, and we've got our business rescue practitioner helping out, there's also the need for the staff to make sure that they feel also more comfortable with this whole process as well. On top of that is basically we've also got further our RAS team as well that deals with further development. They've also chartered accountants that can stand up and also help out with auditing principles. Based on that, what we deliver is a whole value chain of business process efficiencies and making sure the business runs more effectively. And it's not just looking at resources, it's looking at the entire structure of the organization as well and helping building that out better. I'm not sure if that answers everybody's answer.
Yeah. You know what's fantastic about that, Derek, is what's being offered through COBRA is that level of expertise for SMMEs. So it's very special, and thank you, IQ, for that. I have a hand that's been raised. It's from Dustin. Dustin, I'm going to allow you to talk, so I'm about to activate that now. Okay, you're on. Let me unmute you. Just hang on. Let me try again. There we go.
Yeah, thanks very much. I did step away for 1 minute there. I hope I didn't miss what I'm about to ask about. I realize the discussion here is more about business rescue, but with this epidemic, one of the things that we're experiencing is that obviously there's a drop in income, and for instance, we also got clients, and one of the things we run is the student accommodation, for example, and so there's been a huge lag in income. So I wouldn't say that we need business rescue, but for instance, obviously one of our biggest suppliers would be council, and another one of those big suppliers would be like internet services, etc. Now, we would struggle to pay those bills, so we passed the test in the sense that over the next 6 months, we're going to struggle. However, if you look at the way the business operates, we should be able to recover, but only if services are not stopped. So in other words, we may not be able to, and council is always an issue because they always tend to have weird, outrageous calculations. And ironically, they just did that to us. During the lockdown, they've calculated, they've changed rates and done anyway. The point is that we can recover from all of it and we can pay those bills, but not immediately, because we've also got accrued income, and those people that need to pay us are now affected by the lockdown, and they're also kind of saying, we need time to be able to pay you. So there's going to be a lag in that cash flow.
No, great question.
Yeah.
If I can jump in first. So I just want to, first of all, this is a classic case for the COBRA environment to avoid you going into rescue. So the idea would be that we write to the various role players and inform them that you're going to try and avoid rescue by dealing with them. And this is a classic case because it's just a cash flow constraint. So this, you're commercially insolvent. It's known, but you're factually solvent. So the idea would be for us to write, save in one circumstance where we would want you to go into rescue, and that is if you're going to be funding the company by way of additional funds, which would want those funds to be super preferent. So go into business rescue for that. And then I just want to mention, and this is outside of this, but when it comes to the municipal issue that you have, we can assist there. The Schindler's attorneys were the firm that actually took the class action suit against the municipality some time back, where we got an order that they couldn't disconnect. We've got a very, very strong department there, and we can help you out as part of the COBRA pro bono initiative. So let us also help you there if possible. We can then write to the municipality and gauge from them what their attitude is. But importantly, we've got relationships with people at the municipality. In fact, they've got a dedicated legal person there just dealing with Schindler's. So we can cover you there. But when it comes to, like, for instance, the internet service, I don't know if you guys want to come in. What do you generally find when it comes to the provision of services and the sudden disconnection? How do you deal with that?
Well, first of all, you normally allow yourself to carry on day-to-day services. So the moment it's gone into business rescue, all the creditors get parked. Your pre-commencement creditors get parked, as you've correctly said before. But day-to-day services such as internet services would typically need to be serviced on a continuous basis in order for the business to carry on running. You know, obviously in your situation, you've got the, you know, choice to, if your tenants aren't paying, then you've obviously got the choice to disconnect the internet services to those specific tenants, you know, and that could probably act as an incentive to, you know, for them to carry on paying. But, you know, I'm not saying that in a bad way. I'm just saying if they aren't paying you, so that then you can't obviously pay your suppliers. So I don't know if you can disconnect on a case-by-case basis or on a unit-by-unit basis, but yeah, typically things like internet services is not a big part of your typical cost base, and we would just carry on paying that. But you say, yeah, I think in your case, council is the biggest. Will probably be the
council. That's I think we can give you clarity on council's attitude towards it if you approach us. I'd refer you to Chantal Gladwin. You can look her up. I mean, she's a pro at this, and she knows this law really, really well. So yeah, I think the first port of call there would be come into the COBRA ecosystem, and then we'll immediately get an attorney onto council to give you a better idea. Is council the big one?
Council, yeah. I mean, our council bill is, I mean, we've actually got 2 holding entities, but our council bill generally per month is somewhere in the region of 20 to 30. Yeah, so it makes up a large portion of our expenditure. But one of the issues that we have as an ongoing basis is that I don't know why, but council seems to be in a rhythm of backdating and recalculating bills on different tariffs. So we keep getting swapped to commercial tariffs when we actually residential. For instance, now during the lockdown, the one example is that we got a new electrical connection, and we actually went to council, requested the connection, and then also requested a reseller's tariff because we supplying multiple dwellings. And they finally loaded it 2 days into the lockdown and gave us a commercial rate backdated for 6 months. And it's I'd say it's almost 2.5 times what we had been saving up and budgeting for.
Yeah,
and now we've got a cash flow restriction.
We deal with those issues, precisely those issues. And you've because there's a dispute now that you've raised, they can't disconnect the moment we've raised the dispute, and there's an appeal procedure and what have you. So you can actually deal with that claim just by disputing it.
Okay. Yeah, I would really appreciate that assistance. We're quite a young organization, so we don't have the experience.
No problem. Let's set up a Zoom meeting then. Email me, as I said, it's crespi@schindlers.co.za, and then I'll set up a Zoom meeting with Chantal Gladwin, and her team will assist you take it from there.
Sorry, can you just say that email address again?
It's Crespi, CRESPI,
yeah,
@schindlers.co.za, or just go to info@COBRA and just say, please forward this to Maurice, and they will.
Okay.
Your case is a perfect case for business rescue. So this is what business rescue is designed for. It's to go in, get the reprieve, rearrange, and then come out.
Great. Thanks so much. I really appreciate it.
Only a pleasure. Any other questions? If not, I think just quickly put your hands up if there are questions. Otherwise, we're about to conclude. Dustin, I look forward to hearing from you. Thanks, everybody. Thanks to the panelists. It's been a great show. Until tomorrow. Dustin and the audience, just let people know that we're offering this via social media and whatever. There are a lot of people out there who need our services. So it would be in their interests if you were to refer them to us just by posting on social media, anything of the sort. So thank you very much. The end all for today.
Cool.
Until next time.
Thank you.
Cheers all.
All right.